music in our heart and praise on our lips, we declare this day that we are blessed.
Darling, since thou hast placed in thy heart all the Lord's commands, He set thee above nations and cast thy enemies away. He's standing up within thee, so let me hear you say, oh yes, He is. We're blessed when we come, when we go. Confidence in man, everything that does concern thee, you've placed it in His hand, yeah. Though an host rise up against thee to triumph for the day, they'll rush in one road to harm thee, but they'll flee 7 ways. Oh, tell me, yeah. Oh, yes, we are. We're blessed when we come.
Your frequency. Stop this. Greetings. 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 I am King Clifford Jefferson,
Senator Godfrey, the fifth kind of man Jew, son of folk, ruler of Jerusalem, on the reincarnation of King Edward the Peaceful, which we know here at the Third Temple English Church of England as Jesus Christ. It is August 29th, 2025, which is equivalent to the birth year 2975. I greet you in the name of King Edward the Peaceful. I greet you in the name of my Queen Galveston from the House of Galveston. I greet you in the name of Archbishop Belmont from the House of Belmont. I greet you in of all the heirs, successors, all those who want to be a part of this illustrious movement that was founded by I, your king, King Clifford Jefferson, descendant of Godfrey, the fifth kind of man Jew, son of folk, ruler of Jerusalem. This is a beautiful lesson that I have here today titled Revolutionary Breach of the Crown of England's Legal Continuity. The revolutionary breach of the Crown of England's legal continuity. It's going to be a beautiful lecture. I hope all those who are going to be watching today, please subscribe, like, share, subscribe, as well as if you're in comments, so click through $ Clifford Jefferson L, or the Third Temple English Church of England. And with that, to get started with this marvelous lesson, just give me a quick second to make some changes. And thank you all for joining me here today. I don't know why I can't see my comments, but nonetheless, we must move forward. The lesson today is called The Revolutionary Breach of the Crown of England's Legal Continuity. A revolutionary breach of the Crown of England's legal continuity. When I say legal continuity, they meaning the continuance of the government, the continuance of its laws, the continuance of its customs for the people that was prescribed and enshrined to protect. Okay, so this is going to be a complimentary of all the lessons that I've done thus far, and all these lessons that I'm doing as a result of what's transpiring in the courts today on my behalf as Prince Patriarch, the father of the nation. Okay, and let me just show you that real quick. So let you know that I am doing the work that's called upon for any leader to do. Okay, I am doing this illustrious work. So you want to find somebody doing work on behalf of their people, you must look in the courts. Okay, not just going to be accomplished by walking, parading around, or even masking ourselves as fools. Okay, you need to take this lesson very seriously about what you claim to be looking for, and if you have it, and if you have it, is it doing the work that was prescribed? Okay, that's the importance of the legal continuity of the government of the people made by the people. Okay, that's very important. People are going to just look right over that statement, but nonetheless, it's going to affect us all as a result of what we call the last judgment. Okay, and your scriptures is called the last judgment. We call it the doomsday. Okay, that's what we call it, the doomsday. The government that you are now subject to call it the doomsday, or what we call the last judgment. Okay, most of the legal, most of the courts of law was built upon the structure, okay, of what we call the doomsday or the last judgment that you are presently, that right now are presently before you, okay? So this reason why when we look at the scriptures, we don't look at it from the scriptures in reference to the writings of what King James wrote in the Bible, but in accordance with why they were wrote in the Bible, in accordance with why they were actually given to uphold the law, okay? The legal continuity of the law, okay? Very important. This is the appeal for the appellate court on behalf of your king and the nation we represent, called the Crown of England, against the ones who have stolen our land, okay? By way of suppressing the legal continuity of the crown in the kingdom of England, okay? By suppressing the legal continuity of the crown of England, okay? Moved it from where it's at now, presently, to where it's provisionally domiciled, which is at Trenton in Mercer County, okay? Which for the topic is called a shire or 100, okay? Very important. Read for support of the appeal. All the work done by your king. The appendix, beautiful. Procedural history, statement of the facts, standard of review, legal argument, all right? Discrimination and biasness as a result of who we are, what it is we came to do in regards to the property that has been stolen as a result of suppression of the legal continuity, i.e., the political continuity of the Crown of England that was instilled to preserve the protection of the people. Okay, very important. Right, legal argument, conclusion, the appendix, beautiful work done by your king. All precedents, all statutory law that are applicable in your argument in regards to the inheritance, in regards to the so-called Jews, children of Israel, the children of God. All this is very important and is playing out before you in the present day. Okay? And if this is not what you have at your disposal in regard to your arsenal, the ability to be able to fight, then you are in a world of trouble. Standing on the corner or in the pulpits, on walking in the streets is not going to do it. Okay? It's not going to do it. All right? You must understand the legal continuity of our existing customs and laws that were there prior to the revolutionary. All right? Because the fact that these statutory laws and prejudices are still in place shows you that there was a breach in the legal continuity of our government. Right? Just want to read the preliminary statement. Preliminary statement. Appellate brings this appeal for the king's finding of office for the streetman. The king's finding of office of a streetman as to the king's use of anything thus falls under what we call escheatment. Escheatment is the result of the ability to not be able to convey land or property by way of what we call lottery of season versus it being taken, all right, through what we call prescription of sovereignty, okay? So this is what we're subject to. As a result of the heirs not being there, the land has succeeded by way of what we call prescription of sovereignty to somebody who claims to be the sovereign, but in fact they are not. And the only way it can be contested is by the finding of the king's office. It's called acquisition of finding of office, which is said to be the finding of office, okay? Once again, the appellate brings the appeal for the king's finding of office of escheatment as to the king's use of anything in regards to anything that he cheats by virtue of the office of him who inquires it. And the inquisition is found and it is said to be known as to be of office. Okay? Very important term that we all need to understand in regards to whether that office is being filled by a de facto or a de jure entity. Okay? Very important. So we're going to leave that alone. And we're going to go to the purpose and intent justification on the necessity of why it is that your king does what he does. Okay? As a result of the revolutionary breach of the crown of England and its legal continuity. I can't see my can't see my comments. I don't know why. I'm not going to be able to answer any questions, brothers and sisters, until I find out why I can't see my comments. This is the last day of judgment. This is what all the scriptures, all the prophecies we're talking about, okay, about the coming good shepherd, okay? That good shepherd who was supposed to come in the second coming to be able to restore the land back to its greatness on behalf of its people, okay? That scene is not going to take place or unfold like you assume that it is. This is why I always say, he who writes your books set your timeline or how time is going to unfold as you see it, okay? That's why time number one, our ancestors were not, because when the time was unfolded for us to see was recorded throughout time, okay, it will be in our favor, okay? Very important. This is why the lesson is called The Revolutionary Breach of the Crown of England and its legal continuity. We know what the word continuity means, right? The immortality, okay, of our government, okay? The immortality of our government. So just look at it in a concrete understanding, okay? Very important. Write these terms down. Revolutionary Republic. This is what you now have. This is now what you are a subject of, a citizen of, based upon that term. A revolutionary republic, sister term, revolutionary commonwealth. Okay? All applicable today. We'll be jumping, so you got to pay attention. Right? All the lessons that I've done thus far, especially the past 10, is justified by this lesson, or the reason why we do what we do here at the Third Covenant Church of England. Whether you agree with it, whether you like it, whether you don't like it, whether you are offended by it, whether you support it, okay? Your support, your liking is irrelevant if you're not participating in the restoration of the legal continuity of the Crown of England, okay? That was here prior to the Revolutionary Republic, and which the discussion or the topic is today. Okay? A revolutionary republic is a form of government whose main tenements are popular sovereignty, rule of law, and representative democracy. Remember, we're talking about taxation without representation, okay? When we say tax, we're talking about feudal, okay? Representation, we're talking about those who were appointed by what we call apportionment acts, okay? Which was what we call designed by the letter of the law, which is what you call your constitution. A revolutionary republic is a form of government whose main holdings or tenets are popular sovereignty, what they assume is sovereignty, the rule of law, what they assume is law, and what they assume are to be the representative of that newfound democracy. It is based in part on the idea of Enlightenment thinkers and was favored by the revolutionaries during the age of revolution. A revolutionary republic tends to arise from the formation of a provisional government, a temporary government, all right, after the overthrow of an existing state or political regime. It often takes the form of a revolutionary state which ostensibly represents the will of its constituents. Okay? Very important, very simple. This brings on the revolutionary breach of the legal continuity of the government that was overthrown, as stated in the revolutionary Republican form of government. Revolutionary breach of legal continuity. Everybody hold that thought. Revolutionary breach of legal continuity is a concept of English constitutional law, which rationalizes the historic English behavior when one king or regime was disposed and a de facto ruler was recognized as the new de jure monarch or Republican authority. Revolutionary breach of a legal, this is the argument I'm using in court, okay? In the court of law, in the case we just read before, that's before the appellate court, as a result of defending of the revolutionary breach of legal continuity on behalf of the Chancery Court, which was a result of the suppressing of our body of politics, which is a breach, okay? It's a breach, okay? We're going to prove it. Revolutionary breach, which resulted in what you call a revolutionary or Republican or Commonwealth form of government known as democracy, is a result of the breach of the legal continuity of the existing government, which replaces the de jure with a de facto, assumed to be the de jure till it's tested. Okay? That's called the finding of office, the inquisition of office, the traverse of office. Okay? And it cannot be done until a king enters unto the land. Enters unto the land. Okay? Very important. I'm going to go slow with this. A revolutionary breach of legal continuity is a concept in English constitutional law, which rationalizes the historic English behavior when one king or regime was disposed and a de facto ruler was recognized as the new de jure monarch or Republican authority. This is called the demise of the crown. The transfer from one king to the next king, whether it's de jure or de facto, it must be a king. If there is no king, there is a breach of a legal continuity of the existing government. More generally, it is any process unauthorized by an existing legal order, which results in the creation of a new legal order, whether or not the revolutionary change is brought about by violence, by force, by hostility, okay, by coercion, by fraud, by adverse possession. A technical breach of continuity might happen when the former constitutional arrangement is so inefficient that there is not even a practical legal way to amend it. Okay, if you're any type of concerned citizen, you better be listening close. Let's get an example. The United States Declaration of Independence is another example of the revolutionary breach of a legal continuity of government versus the prior one, which was a revolutionary breach of the legal continuity of the English government, which originated at the time of the House of Stuarts under what they call the Glorious Revolution. Okay? Very important. We're not concerned about that because we know that just like the United States Elite said that the House of Stuart dissolved the prerogatives of the king, we see Chisholm versus Georgia says that the founding fathers also dissolved the prerogatives of the king and taking on the folk rights that belong to you as the English subjects, now called heirs by way of the 14th Amendment and the new administration of government founded by the 4th Amendment by Section 1, Section 2, Section 3, Section 4, which we discussed today, which is there's a breach because if they enacted the 14th Amendment and its sections, then the representatives of the government, i.e., the president, the senators, the House of Representatives, as well as any administrator that was running down from there, was supposed to be acting on behalf of their body of politics to make sure that the legal continuity for the English people was protected and that there was no breach. As we see here, the United States, when they declared their independence from Great Britain, they also declared their independence from the Kingdom of England. Okay, which body of politics was right here, known as His Majesty's Provincial Council, known as the Crown prior to 1707 and before 1707, going back to what we call time immemorial. Okay, the United States Declaration of Independence is another example, as it had no basis in the previous legal order, which had governed the 13 colonies and represented the start of a new legal order. A few years later, the replacement of the Articles of Confederation with the United States Constitution was a technical breach of continuity, which did not result in a civil war only because of the very reason of the breach. The United States, under Articles, had a weak central government that therefore had no means to defend itself. Okay? So we're talking about the Republican form of government that you call the democracy is a breach because of the legal continuity of the existing government that was there prior to that breach. Okay? We must understand that. Write those two terms down. What was there before the breach? As students, as citizens, this you should already know. His Majesty's Council for the Provincial Province of New Jersey was the upper house of New Jersey's legislature under colonial rule until it was replaced by New Jersey Legislative Council under New Jersey's Constitution of 1776. Okay? The Provincial Council was established in 1702 upon the surrender by proprietors, which were joint stock companies. They weren't chartered world colonies, nor were there what they call there was three types of colonies. There were world colonies, colonial, charter colonies, and proprietary colonies. So charter colonies and world colonies versus proprietary colonies were totally different because proprietary colonies were stock companies, okay? Corporations, I might add. The Provincial Council was established in 1702 upon the surrender of the proprietors of East Jersey and those of West Jersey of the right of the government, body of politics, etc., to Queen Anne, a de facto monarch, as a result of the breach of the legal continuity of the government that existed prior to the breach, okay, which the founding fathers got their cue from. Anne's government united the two colonies as the province of New Jersey as a world colony, establishing a system of a new government that was, according to what we're reading here, indefinite. Okay? Indefinite. Okay? Indefinite is continuance. Okay? Legal continuity. Whether you were sitting in Burlington or Perth Amboy, the continuity of the government, wherever it sat, was indefinite. Okay? Very important. All right? Instructions were left as before the overthrow. Instructions from Queen Anne to Viscount Cornbury, the first was governor of New Jersey, outlined a fusion of power system which outlined for an overlap of the executive, legislative, and judicial authority and provided for bicameral legislature consisting of both the council and German assembly. On December 6, 1775, Governor William Franklin prorogued the New Jersey legislature until January 3rd, 1776, but it never met again. This was the breach, my brothers and sisters. This was the breach of the legal continuity of the crown that was indefinite, okay? Not over in what we call United Kingdom, now called Great Britain, prior to that called Britain, when they unified in 1707. Prior to that, that government, which we call the government of England, was sitting right here in New Jersey, all right? So we already know that a breach and a legal continuity is treason, okay? We also know that based upon those who committed the breach was not only the House of Stuarts, but it was also the founding fathers who made up the 13 colonies, okay? Very important. And if that is the case, then that would mean that the legal continuity of the crown would be dissolved based upon some legal legislative enactment, okay, to dissolve it, if that was the case. But no such action has been taken in regards to the dissolving of the legal continuity of the Crown of England. Probably Great Britain, yeah. All right, yeah, Treaty of Paris, 1783. That dissolved that government and the authority that that government had over here. Prior to that, the government that was here prior to that dissolvement was the Kingdom of England, okay? We talk about Scotland and France and the conflict they had with England, that's another story. But for the sake of argument today, the government and its function was a fusion of government known as the Crown of England. That is a result of the legal continuity that is reserved right here in the statute, okay? This is the legal continuity of the crown in regards to what we call inheritance for us, the children of Israel, okay, misnominated as Jews, but also Judgment Day or Doomsday for those who call themselves Jews and don't have a right to an inheritance that was promised from our forefathers, okay? This is what we want to for our rescue, okay? Revolutionary breach of the Crown's England legal continuity. This is a proof that our government in the present day, 2975, what you call 2025, is still functioning, okay? The only thing missing is the finding of office, which has now been found. In regard to the king's use of anything resulting from that finding of office and matters of his treatment, okay? And matters concerning his treatment, because his treatment it only results when there is no lottery of season. Whether it's by deed or law, there must be a solemn lottery of season. Contrast to what we call prescription of sovereignty, which is only through the power of eminent domain, which you call the Fifth Amendment. Okay? It is the power to take. Taking something and giving something is totally different in the eyes of the law. Certain tenures and holdings are turned into free and common soakage. This is, in fact, the concept or the purpose of the legal continuity of the crown and matters of its treatment. Hold this thought. Here's the breach right here, brothers and sisters. The letter of the law don't lie. If you got a republic or a commonwealth, which resulted from a revolutionary conflict or war, this is a breach of the legal continuity of that which existed before. And that should be existing now because there was no breach, there was no dissolving in the government. Okay? So as we read here, certain tenures and holdings turn into free and common soakage. Let's read it. Shows you that there is no breach or should be a breach and a legal continuity. There was one with the kings of Scotland. There was one with the founding fathers. Okay, there's one now with what we could now call the states in the union, but there was no breach according to the legislative intent and the common law precedents that I'm going to show you today that support that there is a revolutionary breach and a legal continuity in the government that has now been restored by your king, the King of England, King Clifford Jefferson. All right? The taking of honors, manors, lands, tenements, or hereditaments concerning your inheritance as the children of our Lord, okay? The children of our Lord, of the estate of inheritance at the common law, because the common law is what you call the Ten Commandments or the original Mosaic Code, okay? That's what we call the common law, okay? Because Alfred the Great incorporated in what we call the Doom Book, okay? The Doom Book. So when the last day of judgment came about, what we call the Doomsday Book was a result of the invaders that invaded the land based upon what we call prescription of sovereignty and brought forth the term land acquisition, okay, which you call modern day eminent domain, okay? A record has to be kept. This is what you call the county record, okay? It's called the county record. Oh, this is going to be a good one. The reason why I'm giving this lesson is to be able to articulate this in that court of law, which I'm pretty sure they don't want to do based upon what the language of the statute says, because that's the obligation to determine the letter of the law, not the letter of a scripture from the Bible, okay? Because King James was a king in the Bible, but yet he was ruling on land here in North America as a king of England. De facto, I might add, but nonetheless, a king of England. So if a king of England is de jure and he's a king of Scotland and the office is still here and there's no Scottish king here, that means that there should be a king here somewhere. Where is this king we're reading about right here in 2025? Who has stepped up to take on that tenure in regards to the honors, the manors, the lands, the tenements, or the hereditaments of an estate of inheritance, according to what was promised to the children of Israel once they came into their own and chosen a king amongst their own to represent them as prescribed by the 14th Amendment, Section 2, okay, in regards to Section 1, life, liberty, and property, all right? Because under the Article 1 of the Constitution to Article 13, we were slaves. And we know that from Article 1 to Article 4, the founding fathers didn't have any property, okay? They were just founding up their weak Republican form of government, Article 4. Now comes Article 5, the taking clause, the ability to take something that's not yours, okay? What did they take? That was here already, which belongs to who? The King of England or any other person acting as the King of England, personifying as the crown through the body of politics, corporate by way of incorporation, because we know, what's it? What's the case law? Leeds versus Harrison clearly says that corporate power was originated in the state where the entity incorporated under the state laws, okay? So we incorporated in the state, we incorporated under the state laws, which derive from a corporate grant, okay? Corporate grant, that's through 16:1-28. Right state under charters. Remember, they legislatively incorporated the sovereign charters and a statute, 16:1-28. Right saved under charters. That's a grant. Let's read it. I'm not going to read it. I'm not going to go down with this state. Right saved under charters of Great Britain, saved from repeal. An act to incorporate trustees of religious societies for property placed in corporation in place thereof. Okay? So there was corporations now created, world colonies, charter colonies, property colonies, that took over the manors, lands, tenements, hereditaments, which all an inheritance for the true heirs who were the beneficiaries, known as grantees. Okay? All that would be restored when we were emancipated by the 13th Amendment based upon the parameters of the 14th Amendment and its 5 sections, okay? The fact that that's not being tenured is a breach as a result of the revolutionary breach that goes back to 1776, because it was dissolved by the 14th Amendment, that breach of the crowns of England, what we call legal continuity. It was restored right there. Look at it. Only reason why it's not active because the king. The tenures and honors, manors, lands, tenements, or hereditaments of the estates of an inheritance at the common law held either of the King of England, of any other person or body of parts of the corporate at any time before July 4th, 1776, and declared by Section 3. This is a revision and a conversion of those reception statutes that originated from legislative intent of English parliamentary legislation. Okay? You're reading it right now in its present form. An act concerning tenures passed February 18th, 1795, to be turned into holdings by free income and soakers from the time of their creation and forever thereafter. Shall continue to be held in free and common soakage, discharge of all tenures, charge and interest enumerated in section 3. Okay, so all this was dissolved in regards to that which breached the legal continuity of the Kingdom of England that was there prior to the revolutionary government that you now have in force. Okay, we know that because according to the law, Okay, we're reading right here. In order for you to use anything that was based upon an inheritance in lieu of what we call hereditaments, manors, lands, etc., is based upon how it was conveyed to you to be able to use such property. Okay? How did you get the ability to use that property? How did the United States, how did the colonies get the ability to be able to use the land? Because as we see, according to 46-2, the land was governed by the king who owns all allodial land. Okay? King owned all allodial land. Let's look. Conveyance and uses. Every person to whom uses or uses of any real estate within this state having been sold, given, limited, granted, released, or conveyed by deed, which is one way of lobby of season. The other one's by a lobby of law. Okay? Lobby of deed and lobby of law are two forms of lobby of concession, which means delivery of property. So it says, every person to whom uses or uses any real estate within the state having been sold, given, limited, granted, released, or conveyed by deed, grant, or any other legal conveyance, get at deed or grant. A deed and a grant is not the same. The only way you get a deed is from the grant that's given from the grantee to the grantee, not the seller to the purchaser, or not the lender to the what we call lender, seller, lender, purchaser. What is it? Lender, purchaser, seller, whatever the terms are. We understand that there's a person who actually has full rightful ownership, and the other one who claims to have ownership. Okay, that's the better way of putting it. Okay, so according to the legislative intent, based upon this statute, conveyance of uses, also called the statute of uses, brothers and sisters, this was passed by Henry VIII. Okay, the statute of uses was passed by Henry VIII. So it says every person to whom uses or uses any of the real estate within the state that has been sold, given, limited, granted, released, or conveyed by deed, grant, or any other legal conveyances whatsoever, or that shall hereafter be granted by any deed or conveyance whatsoever, and his heirs and assignees should be held to be in full ample possession of such real estate to all intent, construction, and purposes, as if such purposes his heirs and assignees were in possession thereof by solemn lottery of season, and possession in any usage of custom to the contrary is notwithstanding. We really need to take a look at that language, lottery of season, through the statute of uses, because people are using property, where you're talking about land or real estate, based upon a deed, okay, which is one form of lottery of season. But it just said here that if you have a deed, or the deed granted by a grant, it must be by solemn lottery of season, and any custom or usage contrary to that solemn lottery of season is notwithstanding, especially in the court of law, based upon how a lottery of season was supposed to be conveyed. Okay? Very important. Very important for you to understand that. Let's see. Let's look at lottery of season. And another reference. Cornell Law School. Sure, I know what I'm talking about. Lottery of season. from Cornell Law University. I don't want to believe nothing I say. Okay? Library of Season, according to Cornell Law School, is a symbolic transfer of property during an ancient, archaic ceremony developed by medieval England. Okay? So if you're not doing it based upon that symbolic ancient ceremony, then we have a problem. We have a problem. Season was specific to real property at the time of its use. In traditional versus modern library of season, in traditional library of season, the grantor, the owner, the actual owner, brothers and sisters, would hand the grantee an item like a twig or a dirt from the land. That's the library of season by law. By law. So when you go and pick up that dirt that the ancestors promised you, say, yo, go over there because the grantor can come with us. Okay? He told us to go there. All right? And when you get there, that's your land. That's one form of library of season versus you going down to file a deed at the county clerk's office. Okay? Season was specific to real property at the time of its use. And traditional, which we do, of season, the grantor would hand the grantee an item like a twig or a dirt from the land, which would symbolize the grantee's taking possession of the land. Symbolize the grantee's taking possession of the land. This process is equivalent to transferring property fee simple between old and new owners or signing over the deed to a piece of land. Once again, it's equivalent or soon to be equivalent. Matter of fact, it is equivalent if it's lawful conveyance through library of season. It's not equivalent if it's through formed by adverse possession, which we'll talk about in a second. Okay? So the grantor, once he comes to that possession of the land and picks up a twig or a clump of dirt, that automatically means that conveyance has been transferred, which is symbolic, the archaic, ancient ceremonial way that our ancestors did it when we were promised as the children of England or as the children of Israel or the children called the Jews, which are one and the same to us. Okay? They're one and the same based upon the information I'm going to provide for you today. We can thank Archbishop for that as well. This process is equivalent to transferring property fee simple between old and new owners or signing over the deed to a piece of land. Very important for us to understand that. All right? Why is this the case? Go to the truth. This is one of the parties in the lawsuit. New Jersey Land Title Institute. You go back to did I close that out? This is one of the parties to the lawsuit. If you've seen, we scrolled through the actual appeal. This was one of the parties, New Jersey Land Title Institute. This is the instrument that they use to teach those initiates, I will call them, members of the New Jersey Land Title Institute, which is the practice of teaching how to protect defeasible titles. All right, do what we call title insurance. Okay, title insurance. Okay, as you can read, based upon their material or learning material, history and development of land ownership and conveyancing. Okay. Introduction, historical background of feudalism, statute queen and praetors, decline and collapse of feudal system, conveyancing under feudal system, the importance of season and later development. We're only going to go to section 2 and probably section 3. Okay. They got some explaining to do. For all those who don't know nothing about property law, It's the best way to learn it. When we speak about ownership of land, we refer to the nature of estates or interests acquired or held therein. Land is also known as real estate or real property or realty, as distinct from personal property or personality. The form is characterized by its permanency or immobility, while the latter is distinguished by its mobility. A fixture in an item of personal property, which by virtue of its permanent annexation to the real estate becomes part of said real estate. It loses its character as personal property and becomes a part of the real estate. Okay, so that means that anything that was added on to this land is a fixture. Okay, and becomes part of the estate. Okay, very important. Section 2, 101, 1.02. Historical background of feudalism. Because New Jersey was formerly a colony of the Crown of England. Now, we just read the statute, okay? We're going to get into some precedents to support that. But you see the legislative statute of the legal continuity of the Kingdom of England, the body of politics, corporate or person, okay? In regards to that property before July 1776, July 4, 1776, will remain in free and common soakers. That is the concept of the crown, okay, as a result of the power of escheatment, okay? If there are no heirs, then it escheats back to the crown or the king, okay? Historical background of feudalism. Because New Jersey was formerly a colony of the Crown of England, the history and development of our entire legal system, including our system of land ownership. Now, we're not just talking about the legal system, which means the judiciary, but land ownership has its roots in England. For our purpose, though, we're talking about New Jersey, and that was incorporated in New Jersey. That will be the Corporation of New Jersey Land Title Institute in regards to the intent of their incorporation, which is for the same purpose of New Jersey. It clearly states here, for their purposes, I might add, the development of land ownership began with the successful invasion of England by the Normans in the year, everybody said, 1066. Under the leadership of William the Conqueror, King William I. William I introduced the feudal system to England. Feudalism is based on the concept that all land is held, whether immediately or mediately, by the sovereign. In other words, all land is owned by the king, and all others having a stake and interest in land ultimately derive their interest from the king. Point blank and simple. If that is in fact the case, okay, if that is in fact the case, then I must come here. A picture speaks 1,000 words. As you can see, lottery of season is based upon conveying land to a grantee from the grantor, which should be an heir. Okay? They got it right here in the book. Person dies interstate if there's no heirs, because it is the heir which is considered to be the beneficiary of the trust. If there's no heir, then it automatically escheats. Okay? Escheats. When in the street, it does not involve adverse taking. Okay? Adverse taking, known as an easement by prescription. Okay? An easement by prescription or land acquisition results from prescription of sovereignty, and that is usually as a result of a revolutionary breach in the legal continuity of the government that's already then in existence. Prior to the state of New Jersey existing, there was already a government there. That was the Crown of England. Prior to the Great Britain becoming the government in 1707, there was already a government here. It was called the Crown of England. So both of them was acting off the power of eminent domain through land acquisition, which is a result of prescription of sovereignty, which deals with land transfer from one person, which was the sovereign, to another person acting as the sovereign. Okay? And when that happens, this is in fact the result. The heirs no longer get it, it's somebody else getting it. If it's interstate, then it's the lawyers that were appointed by who? The state of New Jersey, because the state of New Jersey took it under what? The eminent domain power, because the heirs are considered dead in the eyes of law. That's a result of Section 2 of the 14th Amendment, which we're talking about in a section. This, what you see here visually, is the result, what you're going to see literally, based upon the language of the law. The 14th Amendment is reason why you do not receive your inheritance. Okay? Very important for you to understand that. Okay? Let's get it. All right. So they said, because New Jersey was formerly a colony of the Crown of England, the purpose intent for land development and the legal system to support that land development and ownership began with the successful invasion of England by the Normans in 1066. Damn, they went back that far. Okay? They went back that far. Okay? So we go back to William the Conqueror, that would automatically involve what we call the Doomsday Book. Okay? The record. Okay? The record. Here's the record, my brothers and sisters. The Doomsday Book. You called it the Last Judgment. You read King James Version, you get that de facto interpretation. All right? When you read his version about Revelations, the last day of judgment, that's what you get. When you read it from our interpretation, based upon the Last Judgment, based upon William the Conqueror's record called the Doomsday Book, in regard to the Doom Book recorded by Alfred the Great, in regards to the laws governing the Mosaic doctrine, which were incorporated based upon us being what we call the Children of Israel. Okay? Very important, because I'm going to make the connection in a few. So you got to bear with me. The Doomsday Book. The Doomsday Book, when we read the Doomsday Book and it comes from William the Conqueror, then we have to apply that book over here based upon what New Jersey Land Title Institute said about William the Conqueror and their purpose and intent of legal system and land ownership based upon successful invasion of North America based upon the intent and purpose of William the Conqueror, which was through prescription of sovereignty, through land acquisition, which you call eminent domain, which results in adverse possession. Okay? Doomsday Book, the Middle English spelling Doomsday Book, is a manuscript record. Okay? A great survey of much of England and part of Wales, completed in 1086, at behest of William the Conqueror. The manuscript was originally known by the Latin name Liber de Wittonia, which is known as the Book of Winchester. Very important. The Book of Winchester, can we go back to the English Benedictine Monastery and the purpose and intent of what we call the reformation of the church by King Edgar, our Jesus Christ, which I'm the reincarnation of, you will understand the Last Judgment, okay? the Doomsday Book, okay? The Dooms Book, all right? Very important. It says the manuscript was originally known by Latin, named Liber de Britannia, meaning the Book of Winchester, where it was originally kept in the royal treasury. That means exchequer. Where it was originally kept in the royal treasury. The Anglo-Saxon Chronicles state that in 1085, the king sent his agents to survey every shire in England to list his holdings and dues owed to him once the king got back in office by finding of the office, and anything in regards to finding office determined the king's ability to be able to use that property in regards to the prerogatives. Okay? Shire means county. Let's continue. Written in medieval Latin, it was highly abbreviated, included some vernacular native terms without Latin equivalent. The survey's main purpose was to record the annual value of every piece of landed property to its lords, and the resource in land, labor force, and livestock from which the value derived. These are called records, brothers and sisters. You must understand what's going on, brothers. The name Doomsday Book came into use in the 12th century. Richard Fishnell wrote in the Dialogus de Scario that the book was so called because its decisions were unalterable like those of the Last Judgment, and the sentence cannot be quashed. Once again, his sentence cannot be squashed. Very important to understand the Doomsday Book versus the doom that occurred in the times of the kings of England based upon the property that they were what we call trustees of, okay, in a better sense. All right, very important. Name. The manuscript do not carry a formal title. The work is referred to internally as the Scriptio Enroli. In other early administrative contexts, as the King's Brevia. From about 11,000 references that appear to Liber Book and Carta Charter of Winchester. You hear that? Charter of Winchester. Y'all better listen to King Edgar the Peaceful. Okay? You better listen to King Edgar, which I'm the reincarnation of. That's me, y'all. All right? The Charter of Winchester. So all this goes back to the English Byzantine Reformation in regards to the charter presented in Winchester from King Edgar to that personification of that identity known as the Good Shepherd or the Lord Shepherd or Christ. I'm about to make the connection in a second. So the English who held the book in awe, it became known as the Doomsday Book, and in allusion to the Last Judgment and a specific reference to the definitive character of the record. The record doom was the usual Old English term for law or judgment. So if you ain't looking for the judgment day in the law, because that's where the judgment is going to occur, in the law and not in some scripture that's written from somebody who's not a part of the scripture, all right, who's not a part of the script. They just played out the script in lieu of what we call a Renaissance display, all right? So it says the word doom was the usual English term for law or judgment. It did not carry the modern overtone of fatality or disaster, okay? So stop looking at it based upon how you perceive it in the book of Revelation as a fatality or disaster that's going to succumb to people, okay? Richard Fishnell, Treasurer of England, Exchequer under King Henry II, son of Godfrey the Fifth Count of Anjou, son of Folk, ruler of Jerusalem, explained the name's connotation in detail to the Dialogus de Scario in 1179. Okay? And they just called this book Doomsday, that is the Day of Judgment. The Day of Judgment. This is a metaphor for just as no judgment of that final, severe, and terrible trial can be evaded by any subterfuge. So when any controversy arises in the kingdom concerning the matters contained in the book called the Doomsday Book, was a recording of all the kings, tenures, and holders and lands and managements, etc., under the common law is made to that book. Its words cannot be denied or set aside without penalty. For this reason, we call this book the Book of Judgments, not because it contains decisions made in controversial cases like precedents, case law, common law, but because from it, as from the last judgment, there is no further appeal. Did you hear me, brothers and sisters? Did you hear me? The county lists open the king's domains or domain, which has possibly been the subject of separate inquiry. Under the feudal system, the king was the only true owner of land in England by virtue of his allotio title. He was thus the ultimate overlord, and even the greatest magnate could, we know magnates, go back to the judges, could do no more than hold land from him as a tenant. From Latin verb tenant, to hold. Tenure means to hold, which means landlord. Landlord means tenant in chief. Holding a bishop followed the followed. Then of abbeys and religious houses, then of lay intendants in chief, and last the king's sergeants, servants, and thegns. Okay? Very important to understand that your reading is right here in the statute. It says what? That the king held what? All elotio title to land. Okay? So the prophecy of that doomsday book or the last judgment, which was based upon the suppression of those who are clearly not the children of Israel, all right, as a result of the breach, as a result of the Revolutionary War, and any war that came about resulted that, including the ones that's going on today, as a result of the breach of the legal continuity of the government of the Kingdom of England under the authority of the crown. Right here in the statute. Right here. So we take what Wikipedia said about the king and the Lotio land as stated in the Doomsday Book and the last judgment or the final judgment, okay? Then guess what, brothers and sisters? That day is here. Okay? That day is in fact right here, alive and well. Live and well. Listen to this heat, this fire that I'm gonna bring on you. Okay? So the Doomsday Book was a recording of all the tenures and honors of lands issued by the king to whoever it was, whether it was an heir, whether it was a tenant-in-chief, whether it was a knight, etc. Okay, there was a recording, a record, all right, of all things tendered out from the king as a part of his prerogative, okay, by way of a grant. That's the language you're reading right here, my brothers and sisters. Why? Because if the king owns the land, then that means that the land, in fact, must be a lotio. The only way it can be lotio if there are no feudal tenures, okay? Because if the king didn't give out any tenures, that means the land's a lotio. Let's qualify that. Right here in the legislative intent, which is what the courts have to deal with in this appeal. This is what they have to deal with. How is New Jersey acting as a body of politics operating on land based upon some type of authority that they possess to have, but can't prove it based upon the legislative intent of the statute? It says here, feudal tenure estates and interests thereof, taken away, discharged, and abolished by the proprietors, George Corrett and John Berkeley, based upon the charter given to Duke of York, to Charles II, Duke of York, were all dissolved based upon March 12, 1700 and 1664. Right here. That's the date. So there are no feudal tenures because it said right here, they are all abolished. So how New Jersey going to explain themselves? How? How are they going to explain themselves when it says that if all feudal tenures are abolished and the land held in free and common soakage under the king of England body of parts, corporate body parts or person, then that meant that the land is allodial because aren't no tenures given out because the land remains exceeded. Is yet to be figured out by the two ways, library of deed and library of law, which must be done based upon an ancient ceremonial archaic way, okay? And that goes back to Ashton, because he started the process. The great-grandson of Alfred the Great, okay? So if the king had the land in free and common soakage, all right, that is a result of lottery of season, okay? We'll talk about in a second. Let's go to 6. If the land is allodial, then we pretty much are in the Doomsday Book, right? According to the Doomsday Book, the land is allodial. If this statute says this land is allodial, then we are in fact in that judgment day. We are in fact in that judgment day. According to the statute, okay? According to the statute, not what I say, but based upon the law. I only come to fulfill the law or make known the law or personify the law. I'm only doing this because I'm King Edgar the Peaceful. It's my job as a good shepherd, right? I'm the shepherd. You are my sheep. Only my sheep hear me by my voice. The voice is the legislation. I'm not out here speaking because I want to speak. Anything I speak is repetitions of the legislative intent of the prophesying and fulfillment of that prophesying of the legislative intent of the law. Okay? That is my job. All gifts and grants, conveyances made prior to, after July 4th, 1776, the day of the revolutionary breach of the legal continuity of the government that was already in place before the breach. That meant that all gifts and grants or conveyances made prior to and after the breach, July 4th, 1776, of any state of inheritance by a letter patent under the great seal of the state or of any other manner that they can possibly think of by the state, by the legislature thereof, or by the commissioner or agents of forfeited the state, or by any other so-called lawful competent authority under the state, shall be and remain what? Allodial. So this is doomsday, y'all. And no feudal and shall forever be and continue in free pure allodium, only forever discharge of feudal tenures and the instances thereof and all other services whatsoever. So Article 14-3-1, 14-3-2, and 14-3-6 are the legislative intent of the the legal continuity of our government that has been breached. Okay? That has been legally, unlawfully breached by some law that resulted from what we call prescription of sovereignty. Let's take a look at that, my brothers and sisters. Prescription of sovereignty. We just seen that according to the legislative intent that New Jersey or any agency that comes out of New Jersey via corporation, all right, doing incorporation, we know corporate power to rob their authority and it's from a sovereign grant, and that usually from the certificate of incorporation in the state where the entity came alive. So if New Jersey came alive by way of the state statute, New Jersey by statute Title 52, then damn it, guess what? They're not the sovereign. They're a temporary provisionary government prescribed or created by prescription of sovereignty transfer. Why? Because the real sovereign ain't there to contest it. Okay? Until now. Prescription in international law is a sovereignty transfer of the territory, okay, by an open encroachment by the new sovereign upon the territory for a prolonged period of time. Statute of limitations. Acting as a sovereign without protest or other contest by the original sovereign. It is analogous to the common law doctrine of easement by prescription for private real estate. You hear that? The doctrine legalized the de facto transfer of the sovereignty caused in part by the original sovereign extended negligence in or neglect of the area in question. That is called revolutionary breach of the legal continuity. Let's look at it again. Revolutionary breach of legal continuity is a concept in English constitutional law which rationalizes historic English behavior when one king or regime, that means his body, his council, his departments, was disposed in a de facto ruler was recognized as the new de jure monarch or Republican authority. Here they said the de facto acting as the de jure, i.e. the Republican authority. Okay? That's a revolutionary Republican government that was created outside of the law or in violation of the law. More generally, it is any process unauthorized by any existing legal order which resulted in the creation of a new legal order. Whether or not the revolutionary changes in brought about by violence, a technical breach of the continuity might happen when the former constitutional arrangement is so inefficient that there is not even a practical legal way to amend it. Okay? This is called suppression, brothers and sisters. Suppression. Let's go back. Prescription of sovereignty. Now you can look at it, not just from body policy, but as a real estate term. Okay? That's why you see King of England in Title 46, because Title 46 deals with is a statute governing property. Okay? In Crown land is personified by the king, all right, which is for the purpose of intel property. Because if there's no heirs, then it automatically cedes back to the crown as what we call mortmain, a dead pledge. Okay? Prescription in international law is the sovereign transfer of territory by open encroachment by the new sovereign upon the territory for a prolonged period of time, acting as a sovereign without protest of the or contest by the original sovereign. It's analogous to the common law doctrine of easement by prescription. Easement by prescription. Okay? Easement by prescription. Let's look at that now. Prescription of sovereignty or sovereignty transfer is what we call acquisition of sovereignty. Okay? Acquisition of sovereignty. Okay? This is when the conquest, discovery, all those terms come into play. Still, it denotes to prescription of sovereignty. Okay? Prescription of sovereignty is also known as acquisition of sovereignty. It's a number of methods of acquisition of sovereignty are or have been recognized by international law as lawful methods by which a state may acquire sovereignty over territory. Once again, and prescription or acquisition of sovereignty is how a state can acquire sovereignty over territory. Okay, that's through easement. Okay, one way is called accession. Another form is through succession. Another form is through conquest, okay? And another form is through what we call effective occupation. This is called squatting rights, okay? Squatting rights. And there's also what we call prescription, okay? Prescription. So those are the forms of acquisition of sovereignty, which are forms of what we call easements. Very important that you write that down. Let's look at the easement before I move on. Hold that thought, brothers and sisters. So easement. Easement, also called acquisition of sovereignty or prescription of sovereignty, okay? Easement, prescription of sovereignty, or land acquisition is an easement that falls under what we call eminent domain power. That is the same term for all of them I just mentioned. Prescription of sovereignty transfer, acquisition of sovereignty, land, what was called a prescription of sovereignty, acquisition of sovereignty, or easement, also what we call eminent domain, which we define in a second. Easement is a non-possessory right to use or enter into real property of another without possessing it. Okay? So you have the right to use it, but not the right to possess it. Okay? If that is the case, then you must fall within the guidelines of what we call the statutes of uses. The statutes of uses. Let's go back to that statute in case y'all forgot it. Go back to that statute. Right here. Description of sovereignty, acquisition of sovereignty, or what we call an easement, then it must be based upon the statute of uses as you read it right here. Lottery of season. Okay? The lottery of season. I didn't say that that's a legislation. If you're not using it based upon that, then you're in violation of law. Okay? That's what it says. Easement. So easement is a non-possessory right in use of property, right in use or enter into real property. Now we go back to the legislative intent. When you say the right in use, and this is the statute that you're using. All right? If you're using property, then this is the statute or the go-to. Okay? Not precedents, not case law, because they can misconstrue that. They got one case law says this, another one say that. This only says this. If you are using property how based upon the conveyance, then it must be based upon lottery of season and not based upon some prescription of sovereignty or acquisition of sovereignty or easement, which is based upon eminent domain. Okay, if you're using it, then you're in violation of lottery of season because it's not in Sodom. Okay, it's not based upon the ancient uses and customs, and it's just here any way custom and contrary to that is notwithstanding. It's notwithstanding. Let's see. Anything contrary to lottery of season is notwithstanding. Notwithstanding. Any person who uses any real estate under the statute of uses. So we're talking about the use of property. If you're using property, it must be upon solemn lottery of season. Any other usage is notwithstanding. Okay, so this is the defense that the state and the other party has to raise in regards to how they came to be able to use the property in question, i.e., the land in New Jersey, since the statute says the land is allodial. And if it's allodial, that means that there are no figuratives on the land and it must remain a free and common surface. Okay, under the statute. So if you have a tenure and it must be given by a charter, and if it's given by a charter, it must be given by the sovereign. But you don't have a sovereign like they say in the statute because you claim to be a sovereign under what we call prescription sovereignty, and we know that's just not, in fact, the case. Okay? Eminent domain. Let's get these terms out the way. Eminent domain. Okay? Eminent domain. Eminent domain, also known as land acquisition, compulsory purchase, resumption, compulsory acquisition, or expropriation. Okay? It's a compulsory acquisition of private property for public use. Okay? The acquisition of private property for public use. It's right there, brothers and sisters. All right? This is how New Jersey takes property that don't belong to them, because it's doing an easement through prescription of sovereignty, through acquisition of sovereignty, through sovereign prescription of sovereignty. Okay, knowing damn well that you're in fact not sovereign according to what the statute says. The only person that's sovereign according to the statute in regards to property is the King of England. It's in fact the King of England. Okay. So eminent domain, also known as land acquisition, means the same thing. Taking private property for public use, for as long as you compensate them. Well, I don't recall when the English were compensated for the land that was taken from them. Okay, I don't recall any reparations for that. Okay, we must understand that. Why? Because they already said in the real estate book that they took it through the eminent domain power. is the proof. So you can avoid this channel, you can dislike this channel, but the fact remains, here is the God-given proof that New Jersey is, through prescription of sovereignty, acting as a sovereign, and through acquisition of sovereignty of land transfer, have transferred land that belongs to the true sovereign based upon what they call what's the other one? Eminent domain. Okay, eminent domain is nothing more than adverse possession. Okay, adverse possession. I should subscribe. I can't read comments. Sorry for that. All right. So a person dies. That means y'all. Okay? Whether you want to be in there or not, in the eyes of law, you're dead. That meant that the land that was promised to you through lottery of law, which now, once you went out and plucked out your dirt, you have the right to go file a deed to the notary of the republic and file it for the county clerk office, because that's the only one to authorize or acknowledge a deed if it's in fact in line with the statute of uses or not. Okay? So if you're not here as English people on the English common law, that meant that if this land is being tendered out, then it's being tendered out to aliens, whether they're friendly or alien enemies. The fact remains that the land is being tendered as a result of the power of treatment that the New Jersey claims to have by prescription of sovereignty. They're claiming to be sovereign, but the statute just said they're not sovereign. So that shows you a revolutionary breach and the legal continuity of the one who has the power of treatment, which would be the crown or the king of England, to be able to inherit by reverse of abandon the estate that they took him through adverse possession, through what we call hostile takeover, what they call prescription of sovereignty. Okay? Right there, acquisition of sovereignty, law of discovery. I got it right here. Right here, brothers and sisters. So if you aren't listening to me, you are in fact a fool. Okay? So we are right here. We're not even on the map because we don't even have the right to adverse possession, because we know it belongs to us. So there's no need to adverse something that only rightfully belongs to you by way of lottery possession, because its treatment, all right, and eminent domain, all right, its treatment is a result of lottery season falling in what we call inquisition post-mortem. There is no heir to convey it to. And if that's the case, here comes the state, through prescription of sovereignty, through eminent domain, taking land for public use without just for compensation to either the heirs or the grantor. Okay? Once they take it, it falls under what we call adverse possession. Okay? Very important, brothers and sisters. I hope you understand that. Let's go back. Doomsday Book. According to the statute, Portuguese going to do -6. This is doomsday for them. Because it said each county, each shire, or each hundred opens with the king's domains, damsname, which is the king domain, which has possibly been the subject of separate inquiry. Under the feudal system, the king was the only true owner of land in England by virtue of its allodial title. We see this language in New Jersey by statute. Portions going to do -1. The land is, or feudal kingdoms are abolished. Portions going to do -2. King of England, body polities, corporate or person, and the land remaining free and common. So that's the purpose of the crown, all right, and the intent of the crown. And that also Portions going to do -6, that the land is in fact elodial. Okay? Elodial, we see what we read in Doomsday Book right there in the legislative intent and the statutory reception statute, which means that there is no breach in our understanding of the legal continuity of the Crown of England. Okay? There is no breach to us. It's also known as what? The last judgment. Okay? Let's talk about that. The last judgment. What's the last judgment? You read it from the scriptures, from the book of Revelation, the, 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 the statutory law is our revelation to us about the last judgment, which for them is doomsday. Okay? Because it does not involve a fatality or disaster, as told in the book of Revelation. It's based upon the fulfillment of the law or judgment by the law. Okay? Last judgment. Let's look at that. The last judgment in the concept found across the Abrahamic religion and and uh and Zoroastrianism, Christianity considered the second coming of Jesus Christ to entail. You see that word? You see that word. Jesus Christ will entail the final judgment by God of all people who have ever lived. Okay? Jesus Christ to entail. That's the purpose of Crown Land, a record of all those on earth at that time on the land of God, to be judged by God in the last day, called the last judgment, according to our record, the doomsday book. Okay? Very important. And Jesus Christ will entail based upon his intent and that second coming. To you, it's 2025. To us, 2975. This is the day of judgment. Salvation is near, my brothers and sisters, as a result of what Jesus Christ entails in the final judgment, and the doomsday book. Because the doomsday book was a book of record of the land, the census of the people who held land granted to them by the king. Okay? Would be the Lord. Last day of judgment. Let's look up Crown Land, since we're on the topic. Crown Land. Because Jesus come back wearing a crown of glory to restore the land back into its purity, pristine state. Okay? Crown Land. A lot of you, I know a lot of you right now talking about blasphemy. You're talking about blasphemy. Well, this is what Jesus Christ is supposed to entail. Crown Land. If that Jesus Christ who you claim to be coming back is not entailing intel land, you have a problem. Because he's coming back heaven on earth, not uh uh heaven up there, but heaven on earth. Procedural difficulties. Crown Land. We're going to use the very language that we're reading. The very language. So if I can see my comments, I can't see no comments. Crown land. First paragraph. We already know a revolutionary breach and the legal continuity of the crown. Or we know the ground is talking about crown land. Crown land, also known as royal domain or devsne, is a territorial area belonging to the monarch who personifies or incarnates, because you're supposed to incarnate, right? Right, as a child of God, to reincarnate. The incarnation, the second coming, is equivalent of an intel estate and passed with the monarchy being inseparable from it. Once again, crown land, also known as a royal domain, is a territorial area belonging to the monarch who personifies the crown. Bring it into existence, okay? It is the equivalent of an intel estate and passed with the monarchy being inseparable from it. What is an intel estate? What is an intel estate? In English common law, fetal intel is a form of trust established by a deed or settlement that restricts the sale or inheritance of an estate and real property and prevents the property from being sold, divided by will to anybody by due alienation or subjugation, but instead causes it to pass by what? Operation of law. Okay? Operation of law. I'm a beast when it comes to this. All right? Very important for you to understand that, okay? So we're talking about the doomsday, we're talking about doomsday. Yeah, judgment. On judgment. Let's go back to judgment. Last judgment. Okay? Let's read that again. All right. So if you know what crown land is, let's read it again. But with that concept of crown land personified by the king, which is inseparable from it. So whatever he had, he's bringing back with him, or whatever was here, he cannot be separated when he returns. Okay, very important to understand that. All right. Christianity considers the second coming of Jesus Christ to entail the final judgment by God of all people who have ever lived, resulting in salvation of a few and the damnation of many. So we're talking about the Doomsday Book, which is the last book of judgment. Okay, we're talking about the last book of judgment, or also called the Doomsday Book, was supposed to entail the final judgment by God to all people who ever lived. That's a census. That's called the Doomsday Book. Okay, then the only way you can count the census people who are living on land is through crown land, because the only person that being counted are those who have the right to be on that land. Okay, the ones that be on that land. Where's that at? Predestination. Where was that at? Where did that come up? I seen that predestination right here. Was it there? I just seen predestination. Where was that at? Where was that at? Predestination. Where did that come? Right. Predestination Catholic is a Catholic church teaching of predestination, Catholic St. Views on it. The church believes that predestination is not based upon anything external to God. For example, the grace of baptism is not merit, but given freely to those who receive them. So predestination is what you are predestined to prior to you getting coming to that destination. So it's already pre-recorded. Okay, already pre-recorded. We call that the book of confraternity. Okay, the book of confraternity, or what we call the book of life. Okay, very important. All going back to Westminster. Okay, let's build, y'all. Let's build. Last Judgment. Go back there. Michelangelo. I was talking about the second coming of Christ, which is the year 2975 or 2025. This is the last day of judgment. So the last day of judgment is a fresco by Italian Renaissance painter Michelangelo covering the whole altar, a wall of the Sistine Chapel in the Vatican City. It is a depiction of the second coming of Christ and the final and eternal judgment by God of all humanity. The dead rise descended to their fate as judged by Christ, who is surrounded by prominent saints. Okay, so you're talking about the day of resurrection in regards to the last judgment, which we call the Doomsday Book. Okay, the Doomsday Book. Okay, and we said that Jesus Christ was Jesus. King Edgar was Jesus Christ, was under the incarnation of, and the second coming. Okay, that's what I said, right? Well, let's prove it. Doomsday Book, Last Judgment. Okay, Doomsday Book, the Last Judgment, the second coming of Christ. Judgment. Okay, that is very, very, very important for us to understand that. Why? When we look at King Edgar's life, let's go through it. King Edgar. Person right here. All for the church. God's church. God's church, my brothers and sisters. The English Third Temple Church. Let's read it. Religion. As King of Mercia in 958, Edgar granted land to St. Bernburg, Chester. There was an unreformed community, a house of secular clergy, and would have been an unlikely beneficiary of the royal patronage later in Edgar's reign. The Benedictine reformers later presented his ascension as a victory for their cause, but this donation shows the monistic status was not then crucial for him and his advisors. Okay? Early kings had supported reform, but there was only 2 Benedictine monasteries when Edgar came to the throne, and his support was key to the wider success of the movement. In Stetsonville, his ascension to the throne of England led to a few changes in secular personnel, but it caused momentous changes in the church. Okay? Very, 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 very. The Doomsday Book is called the Book of Winchester from the Charter of Winchester. This is the charter we're talking about, brothers and sisters. The Charter of Winchester. Okay? As Edgar, there's St. Peter, there's Mary, flanked by angels. Okay? The book is closed. When you get into the Book of Confraternity, regardless of Concordia, the book is open. Okay? Let's look at it. Book is closed. I'm going to jump. Okay. Let's go down a little bit further with King Edgar the Peaceful. Jesus Christ we're talking about was on the reincarnation of his present day. Let's prove it. Received the front piece illuminated manuscript of the Charter of Anglo-Saxon manuscript written entirely in gold to survive the Anglo-Saxon England. We know a charter is derived from the corporate charter, which is a sovereign grant from the king. What king? Jesus Christ. King Edgar personified that Christ being through his what we call coronation. Okay? And the purpose and intent of the church is the purpose and intent for our church based upon my coronation ceremony, which is not how you see it, but based upon the defining of office. Let's look at this. In the early years of Edgar's reign, the third monastic leader, Ethelwald, was the only abbot whose attested charter showing his special status. He was a strong critic of secular clergy, sometimes called canons, who were able to marry unlike monks. Following his appointment as Bishop of Winchester in 963, Ethelwald converted to the city of New Minster and to an institution exclusive for monks. Edgar successfully sought papal authority for the forcible expulsion of canons and sent an armed force under a royal official to help carry it out. In 966, he granted privileges to the new community and the magnificent charter, see image, which referred to the cleansing of the church. Hear that? Referred to the cleansing of the church by the driving out of the canons and recording the grant of new ministers to Christ by Edgar, who is described as the what? The vicar of Christ, the Charis Christi. One of the most justification for the king's involvement was that the canon's sinful nature meant that their prayers for him were worthless. You hear that? That is the vicar of Christ. Why would he be the vicar of Christ? Let's see why. Continental reformers accepted that secular clergy had their place in the church, and Dunstan and Oswald agreed they did not expel the canons from their cathedral community. Ethelwald was more extreme into the text known as King Edgar's establishment of monasteries. He wrote that Edgar cleansed holy places from all men foulness, not only in the kingdom of West Saxon, but in the land of the Mercians also. Assuredly, he drew out canons who abounded beyond measures in their aforesaid sins. He established monks in the foremost places of all his dominions for the glorious service of the Savior Christ. In some places also he established nuns and entrusted them to his consort, elsewhere that she might help them in every necessity. And that justification. Let's continue. Edgar's support for the reformers earned him an extravagant praise in the works of the Benedictine authors such as Berthworth, and Wolfstan, both writing in the late 90s. The reformers gave Edgar a status which was almost theocratic. He is compared in the Regardus Concordia to the Good Shepherd. The contemporary theologian Elphick of Ensom also praised Edgar. He urged obedience to the monarchy, which he regarded as a divinely instituted. You hear that? The historian Captain Corbard observed that from the very beginning of his reign, Edgar had been portrayed as the able and powerful Basilius whose kinship derived directly from God. He was known as what? The Good Shepherd. What is the Good Shepherd? Let's look at it. The Good Shepherd is an image used in the pericope of John 10, verse 1 through 21, in which Jesus Christ is depicted as the Good Shepherd who lays down his life for his sheep. Similar imagery is used in Psalm 23 and Ezekiel 34, 11 through 16. The Good Shepherd is also discussed in other Gospels. You hear that? Did y'all hear that? So King Edgar is the Good Shepherd, and only the sheep will hear the shepherd by way of the voice, his language, his law. Okay? Why? Because he laid down the law through what we call the English Benedictine reform as a result of what we call the Charter of Westminster. Once again, the Charter of Westminster. Okay? This is what it was all about. Let's just a little more research. The English Benedictine Reformed Monastic Reform, okay, of the Good Shepherd, which I'm the reincarnation as a result of the Doomsday Book. As a result of the Doomsday Book, what was prophesied in the law. King Alfred's Great Code, or the Doom Book, which was a book incorporating the Mosaic Code for the children of Israel, known at that time, now known as the Anglo-Saxons. In the 7th and 8th century England, most monasteries were Benedictine, but in the 9th century, learning in the monastics declined severely. Alfred the Great deplored the decline and started to reverse the decline. The court of Atherton, where the Library of Caesar process took form, the first king of the whole of England, was a cosmopolitan, and future reformers such as Dawson and Ethelwood learned from the continental exponents of the Benedictine monasticism. The English movement became dominant under King Edgar, who supported the expulsion of secular clergy from the monasteries and cathedral chapters, and they're replaced by monks. The reformer had close relation with what? The crown, furthering the interest and depending on its support. This is very, very, very important. Why do I say this? Let's look at the Doomsday Book. Not the Doomsday Book, the Dooms Book. Let's look at it. Dooms Book. You got the Doomsday Book and the Dooms Book. Doom Book, Alfred's Code of Law, or beginning laws, or dooms being the laws of judgment. One and the same. Compiled by Alfred the Great, Alfred codified the 3 prior Saxon codes, those of Ethelbert of Kent and Neo-West and Upper Mercia, which were a separate kingdom before the unification of the Heptarchy, the kingdom of Wessex, to which prefix a modified version of the 10 Commandments of the Moses incorporated rules of the life from Mosaic Code and the Christian codes of ethics. Okay? Very important you understand that what the Doom Book, incorporated by King Alfred the Great, the king of Wessex, okay, encompassing all the kings of Wessex, and with King Edgar the Peaceful was the dominant king through the English Benedictine Reformation of the English Church, now incorporated as the Church of English Church of England by the reincarnation of King Edgar the Good Shepherd, okay, which is known as King Clifford Jefferson in his present day, okay? Very important. Right here. The title Doom Book comes from the Old English word doom, meaning judgment or law, as Alfred admonitions to the doom very evenly. Do not doom one doom to the rich or another to the poor, nor doom one doom to your friend, another to your foe. The reflection of the Mosaic law, which say you should do no injustice in judgment, you should not be partial to the poor, nor deter to the great, but you are to judge your neighbor fairly. If you scroll back up, you see a depiction. Where is it? Down here. Right here. The laws of King Alfred, first page of the laws of King Alfred. The 10 Commandments, brothers and sisters, right there. Okay? Now, why is this important? That the Anglo-Saxons are, in fact, the children of Israel. Okay? Let's go to another source to qualify that. We could thank Archbishop Belmo for that. The English God's Chosen People by Dr. Odo Kuzamula. Archbishop found this. He did a explanatory demonstration on this on his podcast. So you check that out. But nonetheless, I'm going to expound upon it. Out. English as God's chosen people. You see, the Israelites' Mosaic Code was incorporated in King Alfred's Dooms book. All right, the Law of Judgment. The English as God's chosen people. These are not my words. I'm just qualifying based upon the proof that I submitted in lieu of these words. And by Dr. Odo, what was his name again? Kuntemüller. And his book, The Foundation of the 19th Century, published in 1899, Houston Stuart Chamberlain makes reference to the devastation of the Israel kingdom by the Assyrians in the year 720 before Christ, and the carrying into captivity of the inhabitants who in a short time became intermixed with the natives as a consequence of disparity entirely. In the footnote, he adds, they vanished so completely that many theologians, even in our century, are bothering their heads with the questions, what has become of the Israelites? Since they cannot believe that the 5/6 part of the people who Jehovah had promised the whole earth should have disappeared without any ado. We talk about inheritance, i.e. the earth. We're talking about property rights, brothers and sisters. So if you ain't reading those property rights and looting inheritance, i.e. the earth and law, then you're interpreting it wrong. A astute mind even gathered from this that the 10 supposed lost tribes are the English of today. He was besides not at a loss to account for this discovery. This is the reason why 5/6 of the earth's surface belongs to the British, the balance to the Jews. Chamberlain points to two English works treating of this question. H.L. Lost Israel, where are they to be found? Once again, H.L. the Lost Israel, where are they to be found? In our English origin, in our Israelite origin, which are responsible for the fact that they are Anglo-Saxons who trace their genealogy back to the time of Moses. Did y'all hear that? It said it right there. Our Israelite origin, which are responsible for the fact that there are Anglo-Saxons who trace their genealogy back to the time of Moses. We ain't got to just depend upon this. We can go based upon the Dooms book, okay? Chamberlain has known how to relate these theological chimeras to the realm of nonsense, and it's also nonsense that in England this should be taken for gospel truth, okay? So if you're looking at it from a gospel perspective, then you're looking at it in the wrong way, because that portrayal, that understanding is nonsense. To what extent this has been the case, the writer of this experience during his stay at Cairo towards the close of 1887. Here's a well-known Arabian carrier, Muhammad Hassan, showed him a letter that he had received from the English manufacturer of armaments, George Nelson Ross of Sheffield. Muhammad Hassan had served as Englishman during the latter stay at Cairo and followed his departure, and had written him a letter which Mr. Ross answered, and which contained, among other things, the following. When we say Englishman, we know they're lying, okay? Now, as I will tell you something that concerns in particular the future of the Arabs and the Englishmen. God Allah, as you call him, is so good that when he saw how the world was being ruled by badness, he grieved very much. He decided to show humanity the good and right way. For this purpose, he chose Abraham, one of the best persons that ever lived, and commanded him to teach men to love God, to neither lie nor cheat, nor act dishonorable in any shape or manner. Abraham did his best, but what can a person do in a world full of bad people? God now decided that Abraham's descendants, all right, should be charged with teaching his will, i.e., God's will, i.e., God's law. Among other sons, Abraham had Isaac, and God commanded that Isaac's descendants should be teachers. Isaac had two sons, Isaac, from whom all Arabs had descended, and Jacob. God decreed that Esau, his kin, to come should continue to live in free, unrestrained life in the desert and be under no ruler. That's a nomad. But Jacob was to be a teacher of righteousness. Jacob had 12 sons, all became teachers, all of their offspring became what? Let's see. All their offspring became teachers of what? God's will, or God's law, or what? God's commandments. Okay? So if that is the case, then you must be reading that Dooms book. Okay? Not the Bible, because that's nonsense. All right? That came after these texts. These 12 sons again had large families that increased to so much extent that from each family sprung a people. And these ways they came to exist as 12 people. 10 of these 12 people withdrew from the other and called themselves Israel. The other two combined and called themselves Judah. And this way there came about two people, those of the kingdom of Judah and those of the kingdom of Israel. Okay? These people are destined by God to teach all mankind to love God and to treat their neighbors honorably. But instead of doing this will of God, they became bad and cruel. And God sent many prophets. They did not want to give up their sin. Then God became very angry. He drew the people of the kingdom of Israel into captivity and declared that they, in the course of time, should forget that they were the children of Israel. Okay? Forget their ancestry. Forget their birthright. How did promise? He did promise them, however, that he would not entirely withdraw his favor from them. He would send them a wandering and lead them into an island. New Jersey at one time was an island. It was called Beverly, Jersey, where they should find their home. After they had reached, this is called a crusade, brothers and sisters. After they reached this place, they will become the mightiest people on the earth, learn to love God and teach the same to other nations. And then he will reveal to them that they were the lone lost people of the 10 lost tribes of Israel. Let's continue. The other kingdoms composed of the true tribes of Judah were just as godless as the people of Israel. We see it today. For this reason, God sent the Romans to punish them and destroy Jerusalem. All the Crusade Wars and the stories that told prior to the Crusade Wars, these are the extensions of those. More than 1 million Jews, which is the name borne by the people of the kingdom of Judah, were killed. The remaining were sold as slaves throughout Europe. But God promised them that after a while they will once more be restored to Syria and Palestine. And now comes the remarkable part of my story. Now comes the remarkable part of my story. Scholars who have searched the book of Daniel and other books where all these things are written have found that the time for the realization of this is near. They have discovered that the English, as the great teachers of humanity, are the true and rightful descendants of the 10 tribes of Israel, that they live on an island, that they are the mightiest nation on earth, and as have been prophesied, which will be the case. Reading the scriptures today, they are prophecy, brothers and sisters. The scriptures, i.e. the law, i.e. the statutes that we're reading today in regard to English people are speaking about you who are deemed or denoted to as the children of Israel. You're not going by that name now. You're under a different name. It refers to that in the book of which I speak, that so soon as those of the kingdom of Israel assume another name and drop the former, as was prophesied, as happened namely the term English. They should reveal themselves to the effect that they are the descendants of Israel and the brother of Judah, and that they would then take steps to regain what we call Palestine. And as soon as they had obtained, and they would have their brethren, the Jews, taken back to Palestine, and then the Jews and the English would become a great nation and will rule the world, and justice and righteousness would be spread into the world, to spread unto the ends of the earth. This is going to happen in your present day, brothers and sisters. The beginning for this wonderful change on earth is already made. England obtained its protectorate over Palestine 9 years ago, then that over Egypt. Within a few years, perhaps 2 or 3 years, it will have the ownership of Egypt and Syria. A great war will take place in Europe, through which all nations except England, you hear that? Except England will suffer. You hear that? All nations will suffer except England. The Jews will be driven from all countries and will place themselves under the protection of England, just like they did in 1295 under the Jewish expulsion from England under King Edward III first. Okay? The English will receive them with open arms as their long-lost brethren, equip them with everything, the law, and send them to Palestine and large ships for the purpose of having them establish themselves in their own land. So if you are in fact descended from them people over there on that landmass, then this is the remedy, this is the requisite that you need to learn to be able to restore your true estate over there, okay? In those days, remember, the time is near. The English, together with the Jews, which all the Jews, will rule the whole world, and honor and peace and contentment will be everywhere present. The Jews will be the first to rejoice through their connection with the English, and the Arabs the next. You hear that? So why are we fighting, brothers and sisters? The reconciliation is now, okay, through the law, brothers and sisters. It is through the law. Let's move forward. Let's talk about the Dunes, brothers and sisters. Let's talk about the Dunes. The Dunes book, all right, that our ancestors went through, and the Doomsday book in regards to the last judgment and the last day of the return of the lands to the King or the Savior or the Vicar of Christ is King Edward the Peaceful, which was prophesied by law. Emergence of the common law, i.e. the 10 Commandments. Once again, the emergence of the common law, i.e. the 10 Commandments, because that's what they're called now. Okay? That is what they're called now. Hold that thought, brothers and sisters. The Doom Book. You know, the Doom Book was written by Alfred the Great, which is the Codes of Law, which is now known as the Common Law. Right? Okay. Christian theologian Anthony Lee essentially documented Alfred's great work of collecting the laws of code from the 3 Christian Saxon kingdoms and compelled them into his Doom Book. Lee detailed how Alfred incorporated these principles of the Mosaic law into his code, and how this code of Alfred became what? the foundation for the common law. Hence, Alfred's, what's it called? Rex 84, Doomsday Book. Rex 84. Okay? It's not to hurt us, it's to help us, brothers and sisters. So when those who rebelled against the legal continuity of the English government as a result of the breach that took place at the time of the House of Stuarts, the Lancaster branch, the House of Stuarts, the colonists, and the founding fathers, as well as the state, the present state, this is what's going to happen as a result of King Alfred's the Great's plan. Who do you think they're going to rebel against? Right now, military forces is outside of the Washington, D.C. as a result of what's going to take place, as a result of what's coming down the pipe. Okay? They know what's going to happen, but it will come out in favor of who? The English people. Okay? The English people. Let's look at it. Emergence. In 1725, the Kingdom of Kent lost its predominance in Anglo-Saxon England, and the central power moved from the Kingdom of Wessex. The Kingdom of Wessex gradually expanded the area under the rule through annexation and conquest, and by the year 821, a large part of England was under the governance of the Crown of Wessex. Conquest to conquer that was already taken as a result of invasions by what we call Vikings or barbarians, okay? This would be the Danish, okay, or the Netherlands, who are in fact Vikings. The Dooms of Alfred the Great, right here, 849 to 899. Let's read it. The Alfred the Great came to the throne of Wessex in 871 and 821. He was a warrior king and expert in military defense and naval warfare. His successful led to the Anglo-Saxon resistance of Viking invaders. During the war with Vikings, the kingdom legal system fell into abeyance, and with victory came the task of rebuilding. As Alfred stated in the prologue to the Duba, or what we call the Book of Dooms, okay? Or the Dooms book, brothers and sisters. All right? Very, very, very important. All this transferred down to his descendants. Dooms of Edward the Elder, the Dooms of Alston, okay? All this on behalf of the preservation of the land. King Alston, the great-grandson of Alfred the Great. From Alston all the way up to Edmund, okay? Edmund I, the father of Jesus Christ, okay? Edmund, King of England, 939, 946, convened a synod of London and issued a doom addressing matters of clerical celibacy, church dues and alms, and restoration of the church buildings. Edmund's second domes are secular and seek to eliminate blood feuds by offering the kinsmen options to abandon their children. These dooms are provided for the betrothal of maidens and women, okay? Now we have the Dooms of Edgar, okay? The Dooms of Edgar. All the dooms from Alfred the Great to King Edgar's survive in the present day. Let's read it. 4 of Edgar's dooms survived. One was ecclesiastical, but the other 3 focused on the 100th moot court. A 100 was the basic form of local government, i.e. your county. And each shire, typically your county, contained 10 to 12 hundreds. 10 to 12 hundreds, i.e. shire. Edgar's domes required that the hundreds meet every 4 weeks, the borough moot 3 times yearly, and the shire moot twice yearly. Edgar mandated that in the hundreds, as in the other courts, it is our will that in every suit the common law be enjoined, and a day appointed when it should be carried out. Edgar maintains that every man, whether poor or rich, was entitled to the benefit of the common law, and if justice was not so provided, the plaintiff could apply directly to the king for alleviation. That's called a petition of right. Okay, a petition of right. Why is this important, brothers and sisters? Let's look. I come to my close. 14th Amendment. The 14th Amendment, we went from Article 1 to Article from Article 1 to Article 7 and all the amendments, all up to the 13th Amendment. The 13th Amendment emancipated the so-called slaves. So at that time, the so-called slave was not considered a person in the intent for right of suffrage, okay? The right to vote for representation, okay? Because we were at that time slaves. Our freedom did not come until the 14th Amendment. That's when the record started for us, okay? All right? This is when the revolutionary breach of the legal continuity that was restored by the 14th Amendment for the English people. Okay? Let's read it and weep. Then we're going to look at the 14th Amendment again, in the same light. The way you was looking at it was not in light, or was in darkness. The 14th Amendment addressed many aspects of citizenship and the rights associated with what? Citizenship. The most commonly used and frequently litigated phrase in the amendment is the equal protection of the law. Prior to the 14th Amendment, Black people had no equal protection of the law. We can all agree. All right? When we became emancipated by the 13th Amendment, our protection and law was restored by the 14th Amendment and exceptions, okay? The 14th Amendment and exceptions. Section 1. All persons born or naturalized. This is selection. This is called a census right here. All right? In lieu of Section 2. All right? Because without Section 1, you don't have the right to Section 2. All right? And without Section 2, you don't have the right to Section 1. All right? All in regards to the 14th Amendment. I ain't talking about no amendment prior to that, no article prior to that, because Article 1 to the 13th Amendment concerning Black people, we was nowhere in that picture, okay? And under the National Act of 1790, the right to be a citizen was based upon the color of skin, okay? Very important. All persons born or naturalized under the 14th Amendment under Section 1 of the United States is subject to the jurisdiction thereof. We don't have a problem with that. And are citizens of the United States as the state wherein they reside. We don't have a problem with that. No state shall make or enforce any law which shall abridge the privileges or immunities of a citizen of the United States according to Section 1 of the 14th Amendment. We don't have a problem with that. Nor should any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction equal protection of law. Because when we became emancipated, we became free, freemen. And as freemen, we have a right to life, liberty, as well as property. What property? The property we had based upon life and liberty prior to us going into slavery. Okay? Know what I'm saying? Very important to understand that. So the right to liberty, life, you don't have that if you consider property. You can all agree with that, right? So life, liberty, and property came by way of Section 1 of the 14th Amendment. Prior to the 14th Amendment and Section 1, you had no right to property because your ass was in fact property, and the 5th Amendment protected the right of the slaveholders to protect that right to that property, which is their life and liberty, okay? So through Article 1, through Article 7, and the amendments from the First Amendment to the 13th Amendment, the life, liberty, and property for those framers of the Constitution was Black people. You were, in fact, the property. But when they created the 14th Amendment, that became obsolete. Now you have the right to life, liberty, and property. The only problem is that when they changed you from 3/5 of a person to a freedman, they denied you the right of suffrage, i.e., the right to vote for representation based upon the 14th Amendment and your due process right in regard to equal protection of the law. If that is correct, if you don't understand that, you got a problem. Why? Let me show you the problem. Section 2. Representatives should be apportioned among the several states, and that can only be done by census. Our Apportionment Act is based upon the census. Representatives should be apportioned among the several states pursuant to the 14th Amendment, based upon life, liberty, and protection of property for those who came upon the protection of the 14th Amendment. And that was exclusively and inclusively for those persons misnomered as Black people. You were, in fact, English people. Why? Because the 14th Amendment is construed to the English common law. Okay? So representatives shall be apportioned among the several states according to their respective numbers, counting the whole numbers of persons in each state, including Indians not taxed. But when the right to vote at any election for the choice of the electors for president or vice president of the United States, representatives in Congress, the executive or judicial officers of a state, the members of the legislature thereof, is denied to any of the male inhabitants of such state being 21 years of age and citizens of the United States or in any way abridged except for the participation in rebellion or a crime, the basis of representation therein to be reduced in the proportion which numbers of such male citizens shall be to the whole number of male citizens 21 years of age of that state. So if you have 21, you have a right, you have a say-so in lieu of the representation under the right of suffrage as established by Section 2 in regards to the representative, whether they're from the Senate or the House of Representatives, whether they're the president or vice president. The reason why you don't have a say-so is because under English common law, we didn't have president, we didn't have vice president, we didn't have senate, we didn't have Congress. We had parliament and we had a king. Okay? So that's why, in the eyes of the law, you still get to the fifth person. Okay? Very important. Section 3. No person should be a senator or representative in Congress or elected president and vice president or hold any office, civil, military under the United States or any other state who haven't previously taken an oath as a member of Congress under the 14th Amendment requirement under Section 2 and Section 3. Okay? Not any of the amendments or articles prior to the 14th Amendment. We must understand that. So all those officers who hold office now are in breach of the legal continuity of government that was established by the 14th Amendment. Does that make sense to anybody out there in TV land? Come on now. Section 4. The validity of the public debt of the United States authorized by law, including debt incurred by payment of pension, bounty for services, and suppressing the insurrection or suppressing insurrection or rebellion should not be questioned. They mean they don't want to bring that shit up. But neither the United States nor any state shall assume or pay any debt or obligation incurred in aid of insurrection or rebellion against the United States or any claim for loss or emancipation of any slave, but also debt obligation claims to be held illegal and void. Why? Because that body of politics was dissolved by the 14th Amendment. For any claim, any argument, any assumption cannot be brought based upon the legal language of the 14th Amendment and exceptions. Okay? This is the new finding of government, a new finding of office, which has been vacant because of the breach of the legal continuity which was established by the 14th Amendment. And that means that the president, the senator, the congressman, and everybody underneath them had to act accordingly. Section 5. Congress shall have power to enforce by appropriate legislation the provision of this article. What's the provision of the article of the 14th Amendment? Let's look at it. In closing, right? In closing, this is from Jones Freeman, a 19, okay, what year is this? What year is this? Page 30. This is 19, if I'm not mistaken, 50s. (1943). Okay. Oklahoma Supreme Court, 1943. Let's go to page 30. We start off talking about the Doomsday Book. I mean, the Doomsday Book means the last judgment or the day of judgment in regards to a record of all the king's tenures based upon the Doom Book of all those who follow the law that was set forth by King Edgar in lieu of the restoration of the land based upon the finding of office, okay? In lieu of what we call the Dooms Book, because all land is allodial according to the Dooms Book. As I want to start here. Start here. Since I'm coming to my close. Now all this is in my appeal. I'm just building with y'all, but all this is going to be argued in the appeal. All right, based upon the prejudice and what the statute says. The prejudice complement the statute. Okay. And I'm abiding by the statute supported by the common law. In regards to the juror office and the de facto office, nonetheless, somebody must be in office. Okay. Well, acts, I think I'm going to go back. No, listen, y'all. While acts of a de facto incumbent of an office lawfully created by law and existing are often held to be binding from reason of public policy, the act of person assuming to fill and perform the duties of an office which does not exist de jure can have no validity whatever in law. So if the statute says King of England, then if there is no King of England and you operating as if you're the sovereign, then guess what? You're de facto. Okay? Jones versus Freeman. You're de facto because the law set up by our ancestors, it was according to the Doomsday Book, based upon the finding of office, and that's only done by what we call a grand inquest by a jury, a finding of a jury. Okay. So while an act of a de facto incumbent of office lawfully created by law and existing are often held to be binding from reason of public policy, the act of a person assuming to fill and perform the duties of an office which does not exist de jure can have no validity whatsoever in law. So as a result of the office created as a result of the breach, does not justify the office as a result of the juror office that was there that maintained the legal continuity of what the office was supposed to be representing. Okay? We must understand that because that's the argument I'm going to be making in the court of law. Mere possession of a public office is insufficient to make an incumbent a de facto officer. Possession plus color of title to office, if office actually exists, is sufficient enough. Okay? It's sufficient enough. All right? Sufficient enough. How we know that? The Doomsday Book set the standard. The United States said an unconstitutional act is not a law. It confers no right, it imposes no duty. It affords no protection, it creates no office. It is a legal contemplation as inoperative as though it had never been passed. Did you hear that? So if there was a breach of the legal continuity, then in the eyes of that law prior to the breach, that legal continuity still exists. Okay? It still exists. How we know that? We're going to leave it up to the jury to decide this matter. this matter. It says, in Ancient British Presidents, American Law Review, Volume 29, page 711. The old courts of appeals under the Articles of Confederation denounced as unconstitutional laws that assign circuit duties to judges of that appellate tribunal. Judiciary debates of Congress in ancient British Presidents, American Law Review, Volume 29, page 711. In the Doomsday Book, it was recited that what power the king has, he has by law. The greatest inheritance that the king has is the law. For if there was no law, there will be no inheritance and consequently no king. Did you hear that? If you claim to have an inheritance under the law, you damn it, you better have a king, because it said under the Doomsday Book, which is the last judgment in the scriptures, it says that the one who's going to call in that last judgment in regards to the Doomsday Book, going back to William the Conqueror, an invader, which they clearly stated that New Jersey's purpose and intent for their law and their land property rights was a result of what William Conqueror did when he invaded England. So he himself is subject to the Doomsday Book, which is the record he kept, okay? Which, according to that record, he stated that the greatest inheritance that the king has under the law, what power the king has, he has by the law. And the greatest inheritance that the king has is the law. And if that was no law, there would be no inheritance, and consequently, there would be no king. Okay? It's right there in this 43 case. Right there. What else does it have to say? Let's see. About the Doomsday Book. What else does it have to say? Let's see. Why is the courts talking about the Doomsday Book? In closing, the vice basic idea of a state constitution is a popular representative government. The officers being mere agents, not rulers of the people. One where no man is so high to be above the Constitution, and no one so low as to be beneath its protection. Okay? Should the illuminated presidents of history ever be forgotten? Should the landmarks of the fathers in the lighthouse planted upon the shore upon which other states have floundered be turned away? Are the secrets, brothers and sisters, of the old Doomsday Book of the Anglo-Saxons to be read in vain? Or as part of the administration of right and justice, should speedy and certain remedy be afforded for every wrong? A question, brothers and sisters. So if you don't understand the Doomsday Book as written by our Anglo-Saxon ancestors, then you will not have any rights protected under the law as required by the 14th Amendment in lieu of representation at law for life, liberty, and pursuit of happiness in this day and time. Okay? It's very important that you comprehend this fact. Why? Because according to Martin versus Waddell, New Jersey, 1842 case, if the king held such land as trustee for the common benefit of all his subjects and ineligible as private property, and unable to discover on what grounds the state of New Jersey can hold the land discharged of such trust and can assume of dispose it to a private and exclusive use of individuals. If the land is allodial, then how can the state take it and give it to somebody else who don't have the right to allodial land, which is surely is the king? Especially in matters of its treatment according to state versus Standard Oil Company and Ocean Elevator Company, which were closed out. It was a trust estate in the king for the benefit of its subjects, and upon revolution, the government of New Jersey became the trustees and placed of the king pursuant to 61-28, rights seated in charge of Great Britain, state from repealing an act to incorporate trustees of religious society for property held in corporation place thereof. That means that they must be operating under 61:1-28. They're not, because when New Jersey incorporated, it was under New Jersey Revised Statute Title 52, which was a provisionary government, because they did not want that responsibility in lieu of the breach of the legal continuity of our government. Okay? Very important that you understand that. It was a trust estate and the king for the benefit of his subjects, and upon the revolutionary government of New Jersey became a trustee in the place of the king. Remember the office, the trust devolved upon such government, and the land became as ineligible in the government of Jersey as in the hands of the king. Okay? And the state must be bound to hold all such land subject to that trust, which its contented embraces a common right of fishery in the waters and the dredging of oysters and lands covered by the waters. And if this be so, there certainly be no powers in the state without a breach, without a breach of the legal continuity of government for that trust to deprive the citizens or citizens of New Jersey of a such common right and convert these orchards and grounds to a private exclusive use of an individual through their certificate of incorporation, which was not by what we call a sovereign grant. Why? Because according to State versus Elevator Company, the land is allodial. Let's read it. As the statute says, that means that doomsday is here. Because if the statute says the land is allodial and it belongs to the crown, and the case law says that the land is allodial and belongs to the crown as a prerogative, as part of the jure regalia, and that's a matter of right, when there are no kin, then hey, they're in a world of trouble. And not in the ancient, not in the archaic custom usage in regards to lottery of season to an heir or a grantee. All right. It says the modern use of achievement, it signifies the falling of a property to the sovereign for want of an owner. And this category embraces not only property which has no other owner, but also property whose owner or whose owner's whereabouts is unknown. We're talking about its treatment. Let me give you a picture again. Its treatment. Right there. It's treatment. The only way treatment can manifest if there are no heirs, meaning you, brothers and sisters. If you're not here, the only person who had to write this treatment is me. All right? And give it to the new heirs and successors if the old heirs and successors or grantees are not there. But New Jersey, through prescription of sovereignty and land acquisition through the eminent domain power, all right, which is adverse possession, right here, through eminent domain power, they have taken your estate and given to individuals, and knowing that they were supposed to be trustees as established by what we call Martin versus Waddell. Okay? Now back to the case law. If I was a state, I would be scared to argue against the statute and the case law. And modern usage of a statement signifies the falling of property to a sovereign for one of an owner. You said you ain't an owner because under the statute, you said the land is allodial. If it's allodial, then you can't be the owner because if the land is owned, it's not allodial. All right? Especially if he's giving it to heirs. It says, in this category embraces not only property which has no other owner, but also property whose owners or whose owners whereabouts is unknown. Under the common law of England, a street came to be classified or characterized or denoted to as another branch of the king's what? Ordinary revenue. Blackstone commentary, did you want to go there, states that what was originally an incident of a tenure is now an incident of sovereignty. Okay? The doctrine of a street at the early common law and in its modern sense, operative only upon that which was the subject of tenures, since it related to the reversionary right or the amendment right of the Lord to take for one of a tenant, which was eventually extended to include personal property, tangible and intangible. You hear that? The principle was that the right to take that which belonged to no one appertained to what? The crown as part of its what? Jure regalia. The crown steps in to take the property because it's what? It's vacant. Property described as bona vacatated is taken as assumed by the state as its own. Property of this class falls to the crown as a matter of right and exercise of the sovereign power. If the crown is not there to exercise sovereign power, then it falls under bona vacatia under the prescription of sovereignty under the state. Okay? Under the prescription sovereignty of the state as stated by the common law. Where's it at? Mouse got a mind of his own. All right. Once again, the doctrine of mistreatment, according to how the legal and lawful way in regards to the doctrine of mistreatment, says that the early common law operative only upon that which was the subject of tenures, since the related to the reversionary right of the Lord to take for one of a tenant, was eventually extended to include personal property, intangible. The principle is that the right to take for which belongs to no one appertains to the crown, as is jure regalia. The crown steps in to take the property because it is vacant. Property described as by the vacant is taken or assumed by the state until contested. So the state taking under prescription sovereignty until or through land acquisition under the eminent domain power and allow adverse possession, still subject to the right of reversion or the right of amendment of the true owner. Okay? So since the crown steps in to take the property because it's vacant, property described as bona vacatia is taken or assumed by the state as its own. Property of the class falls to the crown as a matter of right in the exercise of a sovereign power. And personal states which are lolio by law, the king is last heir when there are no kindred. Okay? So when the land is lolio and there are no kindred, then the land was supposed to speak to the king, not to the state of New Jersey. Okay? As you see here. Not to the state of New Jersey. How we know that? Because the statute says King of England. It didn't say New Jersey. It says the King of England in regards to free and common soakers. It says the King of England, body, deposit, corporate, or other person. The other person is not the state of New Jersey. Okay? Let's go to another case law that says the same thing. State versus Elevator Company. Says the exact same thing. In personal estates, which are loaded by law, the king is last heir when there are no kin. We read that right there, right? That's common law for you. Okay? So if we go to the law and it says that the land is the lordio, as in the personal state to the king when there's no kin, that means that the only power person has the right to receiptment is the king. All right? So we go to the statute that says the land is the lordio, that meant that only I got the power of receiptment. Let's go to the statute and see. On to law. In closing, if the land is lorted by law, then the king is next heir when there is no kin. So if the law says the land is lordio, then the only heir can exist is me, because according to the law, ain't no heirs, and the land is ceded to the king. So he's the only next of kin. That's called inquisition post-mortem. All gifts and grants and conveyances made prior to or after July 4th, 1776 of any state of inheritance by letter patent under the great seal of the state or any other manner of the state by legislator thereof or by the commissioner or agents forfeit the state or by other lawful and competent authority under the state shall and remain what? Allodial. Okay? Remain allodial. So if it remains allodial, then guess what? According to Ocean Elevator Company, they're in the world of trouble. Let's see what Ocean Elevator Company said before we close out. If the king is next of heir when there's no kin, right? If that's what it says, according to the case law and according to the legislative enactment, which you call a statute, okay? According to that proof, that evidence, then for the state to come as a defendant, let alone a plaintiff, in regards to this matter before the appellate court, would be grave danger. All right? Besides procedural difficulties or deficiencies, like failure to be served by a certified mail. This is the only reason why the case was dismissed by the Chancery Court, to cover up this revolutionary breach of the legal continuity of our government. This is but far more concerning the matter of treatment in lieu of allodial land and the king being next heir. This is but far more than those concerns, and but far more important than the procedural difficulties of a rival or even a multiple system of practical procedure is the grave substantive danger of conceding to the state as the preferred position and the course as a plaintiff in regard to the power of treatment. One of the signal triumphs of the common law, as distinguished from continental systems of jurisprudence, is that for centuries it has been recognized. Okay? It has been recognized. There are principles that everyone is subject to the rule of law. It's in point 7. It says the truth is that for centuries it has been recognized principles that everyone is subject to the rule of law, and that no man is above or beyond the law. Said Braxton, the greatest of early writers in the English common law, Rex non debat essays some whom they set what bread they get quit. Let for Jim. The king should not be under any man, but under the God and under the law, because the law makes the king. And the law who makes the king determines the inheritance that was prescribed by the law in lieu of operation of law. Okay? Very important. All right, so with that being said, one more thing I wanted to hold on, another case law I found. United States versus Smith. Check this out. Close. United States versus Smith. This is a 1952 case, so every bit applicable. The inception of a grand inquest is started in the early reaches of English history. It was a device whereby originally, when first audibly noticed, was in 1166. The Norman kings of England required answers from representatives of local units of government concerning royal property and franchise, and also enforced communal responsibilities for the acts of criminals who violated that law. By gradation, the grand juries gave voice to the fama publica of the locale as the crimes and were later recognized as the character of witnesses. Through the hundreds of years, these characteristics remain inherited. In early stages of evolution, the body made presented indictments at the behest of a private individual or a prosecutor for the king. You hear that? Not anybody, for the king. Vestiges of all these factors still subsist. Okay? The institution was thus involved. The institution was thus evolved as an instrument for efficient prosecution of crime, and as such, it remains until this day. The principle of secrecy was developed to protect the King's Council and to permit the prosecutors to have influence with grand juries, and in modern time is still useful for the same purpose. By degrees, the secrecy of proceedings permitted two outstanding extensions, and the grand jurors at times refused to indict, notwithstanding pressures from the crown and judges. The prerogative stood the people's well in hand during the entirety of the Stuarts, and as to the entirety of the Stuarts, and as it was illegalized by Coke and Blackstone, the institution was incited with all its characteristics in the Fifth Amendment. Okay, the Fifth Amendment, and the Fifth Amendment is the taking clause. Okay, so the Fifth Amendment, the taking clause, was a result of what the Stuarts did, what the House of Lancasters did, and now the Founding Fathers. Okay, but set the prerequisite for how we be able to regain our state. How I know it? Let's look at it. Talking about courts of law, a grand inquest, which goes back to what we call the assize courts, established in 1164, based upon the Clarendon Constitution of 1166, passed by who? Henry, I think it was Henry II. All right, I think I'll touch on that before I close out. Check it out. The king is the bomb. Come on now. We'll finish. Bear with me, let me just find it. Finally done. A grand inquest. All right. The consecutive history of a grand jury goes back to the size of Clarendon issued by Henry II in 1166, as I just said. Henry II was son of Godfrey, the fifth kind of grand Jew, son of Pope, ruler of Jerusalem. So all these laws was for the restoration of Jerusalem once the children of God enter back in Jerusalem, which is called New Jersey, the Garden State, brothers and sisters. The consecutive history of the grand jury goes back to the Assize of Clarendon issued by Henry II in 1166. According to this assize, the accusation was to be made by juries composed of 12 men of the hundreds and 4 men of the township. It presented of men of the hundreds and 4 men of the township. The presentment of a criminal by a jury such as this practically implied that a man was held guilty by the public report of his own neighborhood. A jury accusation is provided for a fact for said jury, ducidum legalius homicius, from the last one, please forgive me, de vicinitio, court and de veritium secundum, I can't pronounce that. I tried. The same machinery for the court of inquiry in lieu of a grand jury, it says here, the same machinery used for the grand jury under the Size Act of the Clarendon Constitution of 1164 and 1166 was the same machinery used going all the way back, employed by who? William the Conqueror in the Doomsday Book. The same machinery used for the grand jury was that employed by the Conqueror when the Doomsday Book was made. Did you hear that? The last day of judgment. Okay? The last day of judgment. Among the miscellaneous mass of presentments that they made about perpetrators, about the usurpation of franchise and so forth, there will usually be a field which can be called indictment for felony. The power inquiry of a grand jury, which dates back to 1166, was originally a power to compel the grand jury to disclose those that were suspect of grave and criminal offense. There go that word again. Grave criminal offense, such as they said in State versus Ocean Elevator Company in regards to the modern use of its treatment, hell, even the ancient way of its treatment in lieu of what we call land that's allodial. The state doesn't have a right because as part of the jurigality of the crown, which the king personifies, it's when the king is next to, when there's no kin, the king is, when the land is allodial, the king is next to heir when there's no kin. Okay? So it's very important to understand that this case will be detrimental to the state to even take a position as a plaintiff or defendant in question of the matter of mistreatment. Okay? So with that, I don't think we're closed out. Yeah, statute clause. Right here. Freedom of religion or the First Amendment, which is called the Establishment Clause, as you see it here. United States of law, Establishment Clause, the First Amendment of the United States, it's called the freedom of religion, is rooted in what? Let's see. The clause was based on a number of precedents, including what? The Constitution of Clarendon. Constitution of Clarendon of 1166, that was established from the Assize of Clarendon, which were the courts of 1164, right here, which you read in that case law, okay? In regards to the doomsday requirement, in regards to what we call a grand inquest usually results in a finding of office based upon the matters of achievement. The Constitution of Clarendon were a set of legislative procedures enacted by Henry II of England in 1164. The Constitution was composed of 16 articles and represented an attempt to restrict ecclesiastical privileges and to curb the power of the Roman Catholic Church and to the extent of the papal authority over England. Did you hear that? Did y'all hear that, brothers and sisters? Okay? Henry II was the son of Godfrey, the fifth kind of man Jew, son of Fulk, ruler of Jerusalem. Okay? The founder of folk right, okay? The founder of the folk rights, which the founding fathers took as their own. Let's quote that on that. Let's see. Give me a second. His father, Godfrey, House, Plantagenet, okay? Who is Godfrey Plantagenet? Same name, Jefferson. Godfrey. His father was what? Who was his father? Fulk, king of Jerusalem. Who fought in the last crusades against Saladin, brothers and sisters. You hear that? So this is our connection to the peerages, to the genealogy, to the historical protection under the common law that was promised from God to the children of Israel, who we represent in this day and time. Okay? So with that, rest assured, brothers and sisters, this is in fact the last judgment. Okay? Judgment of the last days. All right? All right. So with that, thank you all for coming. Thank you all for listening to me. King Edgar the Peaceful is the key to salvation, who were reincarnated through me as a protector of Crown land through our certificate of incorporation. And that is the only way we can restore the revolutionary breach of the legal continuity of our government. All right, restore under the 14th Amendment and its sections. Only mission is the king, his representation, and the people to restore life, liberty, and property. And with that, I greet you as I meet you, as always, in peace and love. Peace.